Every year is an election year. 2022 is no different. 1/3 of the Senate is up for election this year. The entire House of Representatives is up for election this year. Many governorships, state legislature seats, propositions, ballot initiatives, most of which you will never hear about, care about, or think will affect your daily life. And that is exactly how this system is designed to work. Lull you into a false sense of security and hope you never find out who is to blame. Our word of the day is oligarchy, a small group of people having control of a country, organization, or institution. A more blatant example of an oligarchy is having 535 men and women determine what is best for more than 320 million. But a more specific example, lobbying.
There are two ways to affect policy in this country, through the constituents and through the elected. Both methods require calculated messaging, and both have been argued as protected by our country's founding documents. A reading from the Constitution.
Amendments to the Constitution, Amendment 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. It is in this amendment where we find the basis for lobbying. Under the 5th clause, petition the government for a redress of grievances, redress meaning to correct a wrong, lobbying, arguably one of the most harmful practices degrading the efficiency of the government at this time.
It allows a select group of people to usurp the votes of the majority by convincing the elected to ignore their constituents for the sake of a collective. The danger of a collective happens because, in the words of George Washington, people will do what is best for their party and not what is best for the country. I'm going to modify that quote just a bit. People will do what they are told is best for their party and not what is best for the country. Lobbying is about power and influence, not truth or accuracy. And the power to lobby manifests itself in the ability to distort and destroy truth and fact for the sake of maintaining that power. In general, the history of the term lobbying dates back to the early days of this country. But, as the name might suggest, it actually references a common area of a building, the lobby. A public space where common citizens can engage with elected officials outside of the formal setting of an office or the legislative floor.
House.gov says that people congregating in the lobby of the House was necessary because representatives had no offices in the early days of the USA, and the lobby of the House on Capitol Hill was the easiest place in our nation's capital, or even in a state capital, to converse with a sitting representative.
Each state has a different definition of what a lobbyist is, but specifically talking to a representative is not it. Receiving compensation usually determines who receives the title. The National Conference of State Legislatures lists how all 50 states define lobbying and lobbyists.
In the District of Columbia, lobbying means attempting communication directly with a member of the legislative or executive branch in order to effect action by the legislature or administration, and receiving any form of compensation, not just in direct communication, but also influencing others to contact members of the legislature or administration, classifies you as a lobbyist. In Maryland, if your expenses while influencing legislative or executive members are at least $500, and you earn $2,500 because of your attempts to influence communication with legislative or executive members, you must register as a lobbyist. Spending more than $100 on a gift includes meals, travel, drinks, or if you represent a business with a contract or seeking a contract from the government of more than $100,000, you must register. Pennsylvania has a pretty broad standard. Lobbying is any attempt to influence legislative or executive action within the Commonwealth, directly or indirectly. Any gift, hospitality, office expenses in order to promote an interest of a lobbyist or entity. A lobbyist can be an individual, an organization, or a corporation.
On a federal level, a few pieces of legislation have passed in order to affect the ability of individuals and groups to influence policy. In 1919, the 66th Congress approved the Third Deficiency Appropriation Act fiscal year 1919, which is more commonly referred to as the Anti-Lobbying Act.
That legislation read, "No part of the money appropriated by this or any other act shall, in the absence of express authorization by Congress, be used directly or indirectly to pay for any personal service, advertisement, telegram, telephone, letter, printed or written matter, or other device, intended or designed to influence in any manner a member of Congress to favor or oppose by vote or otherwise any legislation or appropriation by Congress, whether before or after the introduction of any bill or resolution proposing such legislation or appropriation. But this shall not prevent officers or employees of the United States from communicating to members of Congress on the request of any member or to Congress."
This act mainly targeted employees and officers of the United States government, forcing them to be removed from their post if they violated the law as passed in 1919. It restricted them from using government funds to influence members of Congress on behalf of grassroots organizations, no matter what their affiliation to those groups. That legislation would become updated in 1946 under the Federal Regulation of Lobbying Act as passed on August 2nd.
This expanded on the anti-lobbying law by labeling anyone who attempted to influence the passing or killing of any legislation to register with the Clerk of the House of Representatives and the Secretary of the Senate. Those registered as lobbyists would have to give full account of their purpose for lobbying, who and why they want to influence legislation, and how much money they receive and use for the purposes of influencing legislation. It was one of the largest attempts to rein in lobbying and its influence. Those names registered with the Clerk of the House of Representatives and the Secretary of the Senate were kept on file with the Registration Unit, Internal Security Section, Criminal Division, Department of Justice, until December 31st, 1995. The Lobbying and Disclosure Act of 1995 went into effect on January 1st, 1996. It repealed and replaced the Federal Regulation of Lobbying Act. The Congress finds that responsible representative government requires public awareness of the efforts of paid lobbyists to influence the public decision-making process in both the legislative and executive branches of the federal government. Now, that legislation has been updated a few times. The passage of the Lobbying Disclosure Act in 2008, now updated as of February 2021 under these most recent guidelines. Lobbyist includes any individual who is employed or retained by a client for financial or other compensation for services that includes more than one lobbying contact, other than an individual whose lobbying activities constitute less than 20% of the time engaged in the services provided by such individual to that client over a 3-month period. A lobbying contact is any direct or indirect communication with what is called a covered executive or legislative employee. Members of Congress, yes. The President and Vice President, yes. But also many staffers and people in leadership positions can be considered covered employees. According to the legislation, once your income from lobbying activities hits $2,500 or your expenses from lobbying reach $10,000, you have 45 days from your first contact with a covered government employee to register as a lobbyist. Basically, at the federal level, you can spend $9,000 on lobbying activities without being required to register as a lobbyist, give or take a few other criteria.
For the record, churches are exempt from being considered lobbyists, even if they hire an outside firm or individual, but that firm or individual must register. Now, even though this act does include public officials who are elected, appointed, or considered an employee, I did not find an explicit prohibition on lobbying judges, so we will say it at best is implied and covered. Also, former government employees must wait 1 full year before participating in any lobbying context. Corporations were not a factor when the founding documents were written, yet the rules have been made to favor their rights because money has always been the most important factor. Corruption in government begins with money and buying influence. Now, we haven't hardly talked about campaign finance reform, which is another way that money disguised as free speech usurps your vote and your influence over your elected officials.
The Bipartisan Campaign Reform Act of 2002 was an attempt to cinch some of the increasing attempts to flood our electoral process with money. You may recall Citizens United, the case that allowed more money into elections, became a factor when the conservative nonprofit corporation decided that the rules were against their interest in an attempt to make an ad about presidential candidate Hillary Clinton available through cable on-demand services, circumventing a rule that centered on publicly available content versus the so-called private access that the on-demand services would require. The justices overturned a rule by the Federal Elections Commission in favor of conservatives' ability to spend money to make any claim they want. Keep in mind, conservatives are the political end of the spectrum that claims to be too poor to be heard by our elected officials, but they champion increasing financial bribery hidden behind free speech protection.
In other words, you're too poor for your vote to matter at the ballot and for your influence to matter once your elected official is in office. As stated in the written opinion, your First Amendment protection should not be determined by your access to money, but the protections overturned by Citizens United give an unfair advantage to those with money, corporations more specifically. You may be asking why I'm hitting on lobbying so heavily, which is a fair question. As I stated, this is an election year. For all the issues highlighted by lobbying efforts such as oil, climate change, electric cars, healthcare, vaccines, immigration, one topic will likely outweigh these as conservatives seek to reclaim power at the federal level: the battle against critical race theory.
As was seen in Virginia this past election cycle, the continued misinformation on what critical race theory is, what it teaches, who it teaches, and what we should learn from it continue to infect the psyche of the American populace. As we will discuss in the next installment of Off the Top, misrepresenting history and adults indoctrinating children by using public education is not a new tactic. In fact, how we view the Civil War and why we still fly Confederate flags is the result of a major lobbying campaign by one organization. While their fathers and husbands were terrorizing the black community and allies, one group of women took their influence to every available state capital at the time. Yes, before we had 50 state capitals. And Washington, D.C. to guide how we learn about their heritage.
What is old is new again, because the efforts of one man revise their efforts to bury truth. In order to know the fallacy of their argument, you have to find the words actually written by the men they defend, and not what they claim those men wrote, but what they actually wrote.
A look at the Constitution of the Confederate States of America, Off the Top.